In this video, I'd like to briefly describe the documents that are used to prepare for incapacity, and specifically the documents associated with making healthcare decisions. With respect to incapacity, the context we need to place this in is something called the Patient Self-Determination Act. This is an act that says that your physician is obligated to follow your instructions. Even if they don't agree with them, they have that obligation. Now the question arises is, what if you were incapacitated? And essentially what we mean by that is, if there's a situation that you can't communicate your wishes, or you can't process the information to make decisions about your own individual care. And so the question becomes, who decides what is the appropriate healthcare decision for you? If you choose to do nothing, the procedure is that a family member, or potentially even the care provider, will approach the court and ask to be appointed as the guardian of your person, and therefore have the authority to make those health care decisions under the supervision of the court. And the procedure in that is obviously time-consuming, expensive, and, well, quite frankly, somewhat embarrassing, simply from the standpoint that it is a public hearing and everything becomes a matter of the public record. We can avoid a lot of this by preparing documents that address these situations, probably the most important of which is the durable power of attorney for healthcare. But related to that is the declaration or living will, and then finally the designation of a designee to make final arrangements. Let's go through these each one by one. The durable power of attorney is probably the most important document that you can have. This is the document that authorizes another person to make healthcare decisions on your behalf when you are unable to do so. It's identified as durable because it becomes effective and continues through a period of incapacity. In terms of who's involved, well, your physician prepares a report of your medical condition. He presents that information to the agent that you have nominated in this document, and then that person is authorized to decide what to do with that information. It could be that they decide to go ahead and file the paperwork in order to activate the power of attorney, which then authorizes that person to make those decisions. It also authorizes you to make a successor agent, so that if the first person you select is not available, then that person who you name as the successor would be able to step into their shoes. The procedure here, again, is that the physician only prepares a report of the medical condition. They are not making a determination of whether or not you are capable of making decisions. That's up to the agent. If the agent chooses to exercise the power of attorney and activate it, they prepare a form and get that filed at the courthouse. In terms of the types of decisions that can be made, your agent will be able to make any medical decision that you could make. This would be second opinions, this would be placement, this could be acceptance or refusal of treatment. And here we get into what makes this a very uncomfortable area. While this document gives you legal authority to make decisions, it doesn't provide any guidance in terms of how to make those decisions or what you specifically would want. And so oftentimes we encourage people to have conversations about what they want, what they don't want. There was a time we used to encourage people to be very specific about what they wanted or didn't want in terms of medical treatment. The problem becomes that medical practice and procedure is becoming something that changes on a daily basis, and so an instruction that you prepare in 2018 may not really be valid or standard operating procedure a year or 2 years later. Continuing on, one of the things you'll see in all of the documents since the revisions that came into effect in 2014 is the question with respect to organ donation and whether or not this is something that you would want to do. It also appoints the HIPAA representation, the HIPAA authorization and the personal representative for confidential medical information. And the question often becomes, what do we do about revocation of these? What if you change your mind? The rule there, as described in the materials associated with the document, is as long as you can reasonably express your wishes in some form or fashion, then the document will be considered to be revoked. And again, these documents can be witnessed or notarized. If witnessed, it must be to disinterested people. That means people who are typically not family members and not hospital representatives or employees. Continuing on, after the healthcare power of attorney is properly executed, I encourage people to contact the persons they have named as their agent and make them aware that they are named, if you haven't already done so, and also make them aware of what your wishes are with respect to healthcare. And you may also want to consider having this placed in the medical file. You may want to consider having a copy made and kept with you on your phone or in the glove box of the car, something where it can be found readily. The next document is the declaration or the living will. And the thing we need to keep in mind here is that the living will has been around for 50, 60 years, something like that. And this was a major step forward when it was first introduced. The idea was that a physician was essentially relieved of the Hippocratic Oath to preserve life at all costs, essentially. The purpose of the document is to really give someone else the opportunity to say, this really doesn't make sense to continue on with this degree of medical treatment. Now, the Iowa Declaration is written in a very particular fashion. This is used only in a very limited set of circumstances. It is when the individual is in a terminal condition or is very likely to be in a terminal condition very quickly. Then, if no other family member is around, if they can't locate the person nominated under the healthcare power of attorney, then the physician can make the decision to withhold or withdraw treatment. Now, keep in mind, this is not a decision that the medical people want to make, and in most cases they need multiple layers of management to approve this before any decision is made. And so it also raises that question of what is a life-sustaining procedure and which procedures you have. Continuing on, you can provide instructions on the document itself. However, this is usually a very poor place to put any kind of instructions, because usually in these situations you aren't going to have people looking for a piece of paper. In these life or death situations, the medical people are going to first and foremost make you stable. They are then going to do whatever they can to assess the situation. They want to bring in that person named as the power of attorney to say, here are 3 treatment options, you tell us what to do. Again, on the document we have the organ donation situation. And when people look at the living will and what it does, what it doesn't do, one of the things that they raise is, do I really want to sign this or not? There's kind of two schools of thought on it. One is that I don't want to have anyone other than a family member making this type of a decision, and therefore I won't sign it. Another approach is to say, I want to send a message to my family that I'm okay with the idea that someone may have to make a difficult decision. And if the family member isn't comfortable doing that, then authorizing or allowing a physician to make the call under the living will might be acceptable. After it is signed, I encourage you to share it with family members, and here again, you may want to add it to the medical file. If you want to change your mind on this, here again, it's a situation where as long as you can reasonably express your desire to revoke the will or just simply tear up the living will itself. One of the issues that arises with living wills in particular is whether or not they have gone stale. For example, if we're in 2018 and the situation arises, we look at a living will that was prepared back a year ago, we probably are fairly comfortable in saying that your wishes have not changed. But if that living will was done 10 years ago or 15 years ago, it raises the question of whether or not you may have changed your mind in that period. The next thing I want to talk about is designation of a designate. The situation here is after you have died, who is authorized to actually make those final arrangements and decide what is to be done? Will it be a funeral, a cremation, a burial, a memorial, whatever? And so the purpose of this document is to put in writing who is authorized to make those final arrangements, and as a corollary to that, who is authorized and responsible to the funeral director or whoever is making those final arrangements to make sure that things are done appropriately and that the appropriate parties are paid. Now, there may be a prearranged funeral that eliminates a lot of the guesswork of this. There may be a cemetery lot that you have already purchased. And again, organ donation may be a part of this. I encourage you to have this conversation with family members because this often is a primary source of conflict. It's occurring at a time when emotions are running high anyway, and oftentimes people are somewhat surprised at the cost of final arrangements. So the real question to ask when you're having this discussion is anticipate what it is that you would want and making those wishes known. Some final thoughts here. These are among the most difficult decisions that you and your family can work through because these are the ones that will cause a lot of emotional anguish in terms of wondering if you did the right thing and if you did what mom or dad wanted to do. With respect to that, it's important, I think, to provide as much guidance to the family as what you can provide in terms of what you want.